Retirement funds administer a significant amount of personal and financial information. What's more, they hold about 4.3 trillion rand in invested assets, which is about half the country's GDP. This combination of information and assets represents a high level of risk when it comes to technology infrastructure and protocols deployed to process information and transactions safely. I've invited Vanessa Jacklin-Levin, partner, and Tshepo Twala, associate, from Bowmans to discuss how to mitigate this risk through compliance with Joint Standard 2 of 2024, issued by the FSCA and the Prudential Authority. Welcome, Vanessa and Tshepo.
Thank you, Natalie.
Thank you, Natalie.
Okay, so let's get into it by first confirming the intention of the joint standard. Tshepo, perhaps you can share with us what the regulators are thinking here.
Yeah, thank you very much, Natalie. I think we just started in the context of, the advent and the introduction of the fourth industrial revolution. It's just a reality that it has transformed how financial institutions interact with their customers. And they've increasingly been deploying more advanced technology and online systems, and obviously, as a result of this, financial institutions are confronted with the challenge of keeping pace with the needs and preferences of their customers who are embracing financial modernization, as well as the improved use of technology in the delivery of financial products and the related services. One of the biggest challenges to financial institutions is the frequency and sophistication of targeted cyber attacks. Financial institutions are the more prominent targets for cyber attacks. And if cybersecurity is not prioritized and managed and developed appropriately, cyber attacks could trigger a breakdown in systems that keep financial institutions functioning and also pose a great threat to the stability of global financial systems. The intention from the regulator, if you read the statement of need that accompanies Joint Standard 2, is clear that, it seeks to enforce a standard for financial institutions to manage and mitigate cybersecurity risks. The Joint Standard requires financial institutions to adopt robust cybersecurity and resilience against some cyber attacks. And of course, while unrelated, obviously this is in the realm of the National Credit Framework, but a recent example that we could be looking at is in the context of a credit bureau in the form of TransUnion. I'm sure you'd have seen in the media a year or two ago where, a criminal third party gained access to an isolated TransUnion South Africa server and obtained sensitive financial and personal data of its South African clients. And you would have seen the information regulator was quite very quick in trying to make enforcement and put certain measures for entities that are obviously subject to POPIA by virtue of the business activities that they conduct. So this is just one example to demonstrate how, for example, financial institutions could also be vulnerable to this form of cyber attacks, and why there's an urgent need with the rise of the technological space that we live in to try and have measures that try to mitigate and avert any threats of cyber attacks. So I think at the high level, that's where the regulators are at this stage. Thanks, Natalia.
So that kind of sets the scene of the environment, or the business environment in which we all operate. Vanessa, I wonder if you could share with us at a very high level what is required on the 1st of June 2025.
So what is required of financial institutions is it's quite a lot. It's quite involved. There's a lot of work to be done. At a high level, firstly, to clearly define the roles and responsibilities of all management functions, including lines of defense against cyber attacks, as well as committees established for the purposes of exercising oversight of cyber risks to your institutions. Establish and maintain a cybersecurity strategy that's approved by the governing body. So that has to either be approved by the trustees or the board of directors, and it has to be aligned with the overall business strategy of the financial institution. Establish, maintain, and regularly review that cybersecurity strategy. You can't just write it up and put it in your drawer. To manage the cyber risk and address any changes to the risk profile as you go along. You have to also conduct risk assessments and maintain an inventory of critical operations and information assets within your institution. You have to implement cybersecurity practices. We have to ensure that access to information is limited to only authorized users and only on authorized devices. You have to develop data loss prevention policies, measures to prevent and detect the unauthorized access or use of information on your systems. Implement endpoint protection to prevent malware infection. Maintain written security standards for your hardware and your software. Maintain capabilities to monitor, detect, respond to, and recover from cyber attacks. Very important, the recovery from cyber attacks. Sometimes they can't be stopped, they can be mitigated, but it's the recovery that is crucial, which means also an establishment of a data backup strategy within your institution. To implement also awareness programs about cybersecurity. As much as you can have cybersecurity, if people aren't aware of how to guard themselves against cyber attacks, and they fall victim to phishing or other strategies by these hackers, doesn't matter how good your security is, it's still going to fail. So very important that awareness. Implement tests on all cyber resilience capacities and security controls in order to assess vulnerabilities. You know, these cyber criminals, they develop constantly. They have new strategies, they have new ways of trying to hack your system. So we have to be resilient to that, and we have to develop faster than they are in our security. Enforce strong password security controls, implement multi-factor authentication for all your users, protect the network from unauthorized access, and make sure that you grant only administrative accounts privileged access, not everyone. So you ring fence certain accounts and ensure that only certain users can access them. And then lastly, to notify the responsible authority of any material cyber incidences in order to comply with the legislation.
It's a lot.
It's a lot.
It's a lot. And I think just to clarify for our audience, you keep talking about financial institutions. Tshepo, I understand that retirement funds are regarded as financial institutions in terms of the joint standard. Is this correct?
Thanks very much. Yes, your understanding is correct. If you have regard to the definition section of the Joint Standard 2 of 2024, it just clearly defines or states that financial institutions, for the purpose of Joint Standard 2, includes a pension fund registered under the Pension Funds Act of 1956. And, just out of interest, it's also worth noting that this also extends to an administrator, apologies for that, of a pension fund as approved in terms of Section 13B of the Pension Funds Act.
I'm so glad, Tshepo, that you mentioned the word administrator, because I was recently chatting, in fact, to a trustee of one of our clients, and she mentioned to me that joint standard is not something that the pension fund needs to worry about. They outsource, obviously, their administration or their system stuff to administrators and investment managers. And so she felt that joint standard 2 didn't have any impact in her world. Do trustees still need to do anything or be thinking about cybersecurity and cyber resilience?
Yes, if you look at paragraph 4.1 of the joint standard, you see it states that governing body of a financial institution, for example, the board of a pension fund, is ultimately responsible for ensuring that the financial institution complies with the requirements set out in the joint standard and the oversight of the cyber risk management. So they may delegate primary oversight activities to an existing or a new committee, but ultimately buck stops with them. It's their responsibility. Furthermore, regardless of a retirement fund's outsourcing of certain administrative activities to administrators and investment managers, trustees retain the full responsibility to ensure compliance with the joint standard in order to comply with their legal fiduciary duties. Trustees always hold a fiduciary duty to act in the best interests of all of their beneficiaries, with responsibility attached to that for managing and safeguarding all the assets within the trust. Trustees are also required to manage the trust at the same level of care as if those assets were their own. And that includes making informed decisions, ensuring compliance with all legislation and joint standards, and managing and mitigating all risks, including cyber attacks.
So what I'm hearing you say is the long list of requirements would apply to the administrator of the retirement fund equally as it applies to the fund itself. So both would need to have, that governance framework around policies, testing, security, all those kinds of things.
Yes, that's correct, Natalie. Your understanding is correct.
Thank you. My last question to wrap it up, and it might not be a pleasant one, but look, non-compliance with the joint standard as it rolls around on the 1st of June next year, what would the penalty for non-compliance be?
Of course, there's several penalties that are attached in the circumstances, but there are penalties that are set out in the Financial Regulation Act of 2017, and in terms of Section 167 of what we colloquially refer to as the FSRA, the FSA may, by an order served on a person, impose on the person an appropriate administrative monetary penalty that must be paid to FSCA if the person has contravened the financial sector law, such as the Joint Standard 2 of 2024. And the quantum for such a penalty is theoretically uncapped, and the determination of administrative penalties considers various factors, including the need to deter such conduct and the seriousness of the contravention. And, where the FSA does make a financial or a final administrative penalty order in terms of Section 167 of the FSRA, the FSA is compelled without discretion to make public the terms of that particular order. And this is usually done by the FSA, and we usually see those particular orders being published on the FSA's website. And I think just to also set out a couple of other types of penalties that would potentially attach to non-compliance with Joint Standard 2 of 2024, I will hand over to Vanessa to just set out several types of legal consequences that would attach to that particular non-compliant.
Sure. So, as I said, a trustee's job is never done, and a failure to perform their duty not only undermines the purpose of the trust, but also can lead to severe legal consequences. So, for example, you could be removed from the trust as a trustee, effectively fired, if you have failed to comply with your duties. You could face financial penalties as a trustee. You could be personally liable for losses suffered by the trust due to your actions, which could include compensation or damages for any loss of profit or illegal personal gains that you have made through your position as trustee. You could be required to repay profits because of the breach of trust. And you could also face criminal charges in severe cases where there is evidence of theft or fraud. Trustees can face criminal charges resulting in fines and or imprisonment, depending on how severe the offence is. And then there's always the threat of civil lawsuits. So beneficiaries are entitled to institute civil lawsuits against trustees for the breach of their fiduciary duties, which could lead to substantial damages having to be paid by the trustees to the beneficiaries. So it's the penalties are severe. One does have to comply with one's duties.
I just want to just go a little bit off piece there, because you spoke about personal liability of trustees, and when you mentioned that, my mind went to a space of a scenario where someone hacks your systems and holds your pension fund data ransom. And it's an interesting question. Who would pay for that? And is there a scenario where trustees could be financially responsible for that?
There is. I mean, if they were involved in any kind of negligence, particularly gross negligence, in respect to not having complied with the standard or putting reasonable measures in place, they could be held personally liable for their actions. Or perhaps they were part of the decision-making committee who made decisions on what to do or what not to do in respect to cybersecurity, which was negligent or incorrect in some way. Then they could be held liable. I've actually recently dealt with a matter in private arbitration where a business was the victim of a cyber attack, and we acted for them in suing the service provider who had neglected their duties in putting in the required security, firewalls, and data recovery. Most significantly was the data recovery failure, because as a result of the cyber attack, our client's business suffered substantial damages and never, ever recovered the data that was lost through the cyber attack, resulting in millions and millions of rand in a damages claim, which ultimately was paid to our client in the arbitration proceedings. So there are substantial consequences, particularly financial consequences.
Scary stuff. As mentioned, retirement funds deal with an extensive amount of personal information and invested assets. Bring along two pots, and suddenly the number of transactions are also increasing. And I think in this realm, trustees and administrators need to prepare for and guard against cyber threats. Thank you, Vanessa and Tshepo, for joining me on EBNet Stream.
Thank you, Natalie.
Thank you for having us, Natalie. Appreciate it.